Hi, folks. Welcome to the Stringer LLP webinar, The Road Back, Safety and Employment Law Considerations for Reopening the Workplace. My name is Ryan Conlin, and I am joined by our firm's managing partner, Landon Young, who we're to cover for you the basis of as to how employment law and occupational health and safety law are going to operate in this new environment. For those of you who want just to take care of a few housekeeping items, for those of you not familiar with us, Stringer LLP is a labor and employment boutique firm based in Toronto. We've been in existence for a number of years, and we've been helping our clients through these very trying and legally complex times. I mean, Landon and I were just speaking of just how the law is evolving constantly in this area. And it seems to be new, every day there's a new announcement of a regulatory change or a new program being put in place by the government. So we have a lot to get to. Obviously, for those of you who don't know, it appears that these emergency orders in the province of Ontario are going to be extended by the Ford government till the end of this month. But at some point, obviously, and the economy is going to reopen, and then we're really probably, hopefully, getting into the weeds on that fairly soon. So it's my intention to take you through the occupational health and safety aspects of the return to work process and what things you have to consider. After that, Landon's going to touch on a wide range of employment law, human rights law, and privacy law implications that arise in this area. For those of you on the call, many of you who come into an office environment or other area that's not particularly safety sensitive are probably used to having health and safety really be the top priority. I mean, you know, a law firm obviously we all care about safety, but you know, it's not a mine, it's not a construction site, so it's not something necessarily that is necessarily top of mind. But COVID-19 has turned the world on its ear. So for some of you, this, you know, some of the stuff in this legislation is going to be quite new. Wanted to start off with the basics. The Occupational Health and Safety Act, and for those of you who want to look it up, it's section 25 sub 2 sub H as it pertains to employers, have what's called the general duty clause, sometimes called the bucket clause, where if the legislation doesn't address a specific issue, the legislation and the regulations thereunder spell out all kinds of specific issues that are interesting. But I think the key, and they set out some of the key thresholds, right? Like, so you have to wear a hard hat, you have to wear fall protection if there's a risk of falling for 3 meters, things like that. But the general duty clause just says that where the law doesn't specifically address something, you have to take every precaution reasonable in the circumstances to protect worker safety, which obviously there's room for ambiguity in that as to what that actually means. Certainly, the courts have held that, thankfully, employers are not required to take every conceivable precaution for occupational health and safety. But the courts more recently have held that some employers are required to exceed the standards prescribed by legislation in some instances. So ultimately, where we're at, most of these COVID-19 issues are going to be covered by this general duty clause. You have to do as an employer what is reasonable. And also, I think it's important to appreciate that the Ontario government has issued guidance in conjunction with the Safe Workplaces Association, things like the Infrastructure Health and Safety Association and others, which are essentially quasi-government agencies that are funded by the Workplace Safety Insurance Board premiums, that have given out specific guidance about what should be done in terms of making the workplace safe. And if any of you who have reviewed these, and I imagine that some of you have, the industry-specific guidance does not have the force of law. Right at the top of it, perhaps self-servingly for lawyers, it says, this guidance does not constitute legal advice. If you want legal advice, call a lawyer. Like we're somehow all the oracles of knowledge about what one should do about protecting health and safety. But that, you know, that's the standard government sort of default. But you can assume that even though it doesn't have the force of law and you can't technically be required that officially to be required to follow that guidance. You can assume that Ministry of Labor inspectors will be looking at that guidance as kind of the basis for their enforcement, right? It's a government publication. For some of you, I'll also encourage you to take a look at the website of WorkSafe BC in British Columbia, which is the equivalent to the Ministry of Labor out there. That organization, BC is obviously more advanced than we are in terms of COVID-19. They have far fewer cases. In fact, some children are going back to school in the province this week, so they're well into this. There's a fair bit of guidance on their website as well, which most of which would be also quite relevant and somewhat more extensive, and certainly they're further down the road than we are in the reopening process. Obviously, also this guidance for those of you, especially those of you that are unionized, it may be something that a labor arbitrator or other in another dispute forum will pay a fair bit of attention to in terms of these guidelines. I can't go into the contents of it. They're very industry specific and very and there's a huge number of them. But in general, they speak to such things. If people can work from home, they should. For the office context, their social distancing should be maintained. Masks should be worn where social distancing is difficult to avoid. Hand washing, hand sanitizers, physical barriers, all those things are common to all of the criteria. And none of this probably comes as a surprise, although we've certainly seen some of the health and safety advice from the professionals evolve during this time. Certainly at the beginning of this crisis, some of the highest ranking scientists in Canada and elsewhere were saying that masks, were not particularly helpful. And now, they're considered to be certainly valuable, at least in terms of protecting other folks from contracting this virus. I wanted to go through a scenario because, look, we all know that when we get back to work, there's going to be, issues that arise. And the one that's going to come up is something like this, I think, fairly frequently. The guidance for office settings suggests that only essential meetings with clients or others be conducted in person. That's the words. Basically, what the Ontario government is saying, look, is unless it's essential, you shouldn't be meeting with people in person. Let's meet electronically via Zoom or Microsoft Teams or conference calls or whatever on the internet. An employer requires sales staff to meet with clients in person at the company's facility. A worker, when it asks the employer to switch to virtual meetings with clients until the COVID-19 situation is resolved. The sales manager thinks that in-person meetings are essential to the business. Well, these are the kind of debates that we're going to have. What rights does the worker have, and who determines what's essential? I mean, because obviously that's the one thing. Like, the government guidance says essential, but no one has really defined what essential means. Like, we've certainly, if you look at the regulatory environment, essentially people have argued that a liquor store is an essential service, right? And it's one of the things that has never closed. And certainly, I mean, one could query whether a retail liquor operation is essential to the survival of society, maybe for some folks. But I mean, it's, again, so what essential means is open to interpretation, like all things in law. And so what rights workers have comes down to work refusals. Workers generally have the right to perform work that they consider to be to refuse to perform work that they consider to be unsafe. The right to refuse is limited by the language of the legislation. And on the next slide, I'm going to take a look at what the actual language of the legislation itself actually says. There are exemptions to this for those of you who are in emergency services, such as hospitals, law enforcement, jails, that sort of thing. Those workers are outright exempt from the legislation, and the reason for that, I think, is fairly obvious, and that's universal. That's fairly universally true across Canada. Disputes about work refusals, where if someone is unsatisfied with the outcome, the remedy is to go to have the matter ultimately adjudicated by the Ontario Labour Relations Board. So, I mean, I think historically that when we think of work refusals, and the very structure of the legislation itself is that someone who's refusing to do work is in the facility, right? Like, usually where a work refusal was, when this legislation was drafted decades and decades ago, it had in mind that, if a particular piece of equipment was faulty, or if a particular work process was unsafe, the worker would refuse to do it. They would stay in a safe place, and then a decision would be made. How work refusal provisions operate is fairly straightforward, in the sense that what's contemplated by the legislation is a two-stage process. The first stage being that the employer and the employee try to work it out amongst themselves internally with the Joint Health and Safety Committee. I mean, I'm oversimplifying this a little bit, but in the interest of time, we'll just say that there's an intent to resolve the matter internally. And if that doesn't happen, the employer then is expected to contact the Ministry of Labor, and then an inspector makes a decision. As you can imagine how difficult that is in these times, where inspector resources are spread thin. I mean, we've certainly seen issues around what inspectors are willing to do and not do in terms of what kind of facilities they're prepared to enter into in terms of their own safety. So these matters are often being adjudicated on the phone. I can tell you that my experience is consistent with published reports on this, in that the Ministry of Labor has not been particularly anxious to sustain work refusals for those operations that are in fact ongoing. And although many of those operations are exempt, the ones that are not, there hasn't been dramatic enforcement efforts by the Ministry of Labor itself. I wanted to take a quick look at what the work refusal provision says and what it doesn't say. It says a worker may refuse to work or do particular work where he or she has reason to believe. And I think that what's important is sections B and C on this slide. One, the physical condition of the workplace or the part thereof in which he or she works is likely to endanger him or herself. That's the provision. But take a look, carefully at the term endanger, and one would assume that contracting the virus is encompassed by danger. And lastly, it's sub C, that any equipment, machine, or device or thing he or she is to use or operate, or the physical condition of the workplace or the part thereof in which she works, is in contravention. So really, the words that are in the legislation are the physical condition of the workplace. That's really, so the work refusal provisions really have to relate to something that's in the section and in the section only. So it really, a lot of this is going to come down to issues that relate to the physical condition of the workplace. And notice what this provision does not cover, at least it does not cover the physical condition of the subway car on the way to work, and things along those lines. It's a very, it's a relatively narrow provision, which quite frankly was probably never drafted with something like this situation in mind, as no one quite imagined a replay of the influenza epidemic, of course, now some 100 years ago. I think employers must be prepared when you're dealing with work refusals with clear reasons why the work refusal is unfounded. Like, a lot of these things are going to come down to disputes about specific precautions that are taking place in the workplace. As I had said, that you're going to have to assume that the person's going to be making this work refusal possibly from home, possibly without ever having shown up in the workplace, and just sort of a blanket refusal to work because they think it's unsafe to return because of COVID-19. Remember, you go back to what the actual section is, and I'll go back to that slide again. They have to really specify what it is. They're going to have, like, a work refusal to be valid is not just a blanket general, I think it's unsafe. The Act says it has to be something specific. It's the physical condition of the workplace, and what aspect of the physical condition is it? I mean, that's what speaks to it. I mean, certainly, arguably some of the things that come up under COVID-19 and aren't covered by this section. So the first thing you want to do, you want to take all issues that people say seriously, but you have to recognize that the work refusal provisions are narrow in dealing with certain things only. I think that that's kind of one of the strategies that needs to be borne in mind by folks. So you also, of course, have to pay attention to whether or not the worker or work is in question. If someone's exempt, of course, they're not subject to that issue. You want to involve the Joint Health and Safety Committee at an early stage with planning for return to work. I mean, I know this is trite to say, but this is a considerable challenge in this day and age when most of us have now been out of the workplace through mid-March, and for most of us that may very well be the case till the end of June at the earliest. And frankly, we've heard from some major downtown Toronto employers that they're not planning on bringing their workforce, much of which can probably work remotely anyway, back into downtown until at least September. So it's a long time to be apart, but you want to engage upon these issues now. I mean, certainly a good starting point for those of you that are in buildings that are owned by a landlord. The landlord, I assume, if he's anything like our landlord at our firm, has provided a fairly detailed plan with how certain safety issues are going to be dealt with in terms of how the building is going to be accessed, who can access the building, when they can access it, the use of elevators, how that's going to work, times, and those sort of things. You want to share that document with the Joint Health and Safety Committee and your workforce at large to build. As part of your return to work plan, you're going to have to plan to deal with the restrictions that are set up by your landlord or any other party that has control of your workplace. That's a good place to start, but it also gets to be a good sounding board. I've certainly heard from clients that there is a huge range of reactions to some people that are chomping at the bit to get back to work, and frankly are probably not as concerned as they ought to be about health and safety, versus those that are in a situation where they are very worried about going back to work. And of course, in the bullet there's also those, and this is human nature. It's a small minority of people, but there's going to be people who are initiating a work refusal to advance a labor relations agenda. Landon's going to talk to you a little more about, from an employment law perspective, dealing with those that might prefer to be on some sort of government benefit of one kind or another rather than return to work. And that we're hearing some of that with some of our clients that are getting people back that are permitted to go back. So you have to be prepared to deal with that notion that some of these are simply someone advancing another agenda. But using the Joint Health and Safety Committee is a valuable issue. And if you get a formal work refusal, you can probably assume that it may not be, especially when there's a whole bunch of workplaces going back, that you might not hear back from the Ministry of Labor as fast as you like, or get the world's most thorough decision. To be fair to them, they're dealing with a fair number of, I assume they'll be dealing with a fair number of these situations. We hope not, but I suspect they will. Just a quick reminder for folks is the work reprisal provisions. You're not allowed to engage in a reprisal against a worker for exercising their rights under occupational health and safety. And that doesn't just mean fire them. It could be a demotion. It could be putting them on unattractive hours. Essentially, it's some type of adverse consequence for exercising their rights under health and safety legislation. And one of the mistakes I think that's sometimes made by employers is this blanket fear that the second someone raises a health and safety issue, that they become paralyzed and don't make a decision. You want to be as sensitive as you can, and you got to recognize that it's your burden to prove that whatever action you took was made in good faith. However, you should not let a fear of a reprisal application paralyze you. In fact, many of the employees that raise reprisal applications haven't actually been exercising their rights under health and safety law. In order for it to be a reprisal, they have to be referring to the Occupational Health and Safety Act and a specific provision thereof. So in the context of COVID-19, it's probably going to be the general duty clause, but they have to be making a specific comment about occupational health and safety in order for the reprisal provisions to apply. And if they don't, then the labor board or an arbitrator doesn't have jurisdiction to hear the case. That being said, you should be aware that Ontario employees, through the Office of the Worker Advisor, has a dedicated team of people who bring these cases, right? And some of you who've ever dealt with one may have dealt with this office, so they're probably going to get very busy. And it's been my experience that they, will file these cases, some of which have merit and many of which do not, at least in my client's view. But you got to recognize that, there is free representation available for these kind of cases. So in that instance, that's attractive to a worker because they then don't have to share the proceeds with the very entrepreneurial plaintiffs bar that you're going to hear about in a moment. Let me give you a fact. Let's just try to do a little more deep dive into this work refusal issue. This is a scenario about sort of, because every one of us I'm sure any one of us have had these employees that, think have seen something in the newspaper and all of a sudden think the employer should do it. An employee of a pallet plant suggests to the company that anyone accessing the facility should be subject to a temperature check. The company considered the idea, like they talked about it, but it's not in the scenario, so they brought it to the Joint Health and Safety Committee and decided it was not an idea worth pursuing. They thought that the process would be cumbersome and expensive. I mean, and the employee phones the company and announces he is initiating a work refusal. How should the employer respond? Well, one of the first things to avoid doing is not getting angry, not getting frustrated from the perspective of, but what you want to do is just very calmly and dispassionately. If you can't resolve it with the employee, he insists there should be a temperature check. And ultimately, this relates to the physical condition of the workplace. I mean, you could argue it's not, but I'm not sure that, the jurisdiction is the world's best path here. I think what I would do is just explain to the Ministry of Labor we considered the idea, and that, quite frankly, our review of the science on this is that there seems to be mixed messages on whether this particular issue is of any assistance. We have a robust policy saying that any person that has COVID symptoms should stay home from work, and if anyone appears to have those symptoms, they'll be sent home. That's an obligation. Frankly, the temperature check. This is not like an airport. We're not in a facility customarily accessible to the public. The only people who come inside this facility are employees of the facility, and therefore that other people are heading in that scenario. We just don't want to head in that direction. And I think if you do that, the chances of the Ministry of Labor requiring you to implement temperature checks on those facts are fairly limited. So, because remember, it's always up to management to manage. Joint Health and Safety Committee, I've alluded to this before. I think you want to involve the Health and Safety Committee in the planning process right away, as I said. And remember that the committee has the power to recommend solutions, but cannot impose decisions. I mean, there is sometimes a misunderstanding on the part of some militant members of Joint Health and Safety Committees that they've taken over the company, and if they say something, it should be done. It should be taken very seriously, and if a particular recommendation, let's say the temperature check example from the previous scenario, you need to document why you didn't follow such a thing, because you know that the Ministry of Labor inspectors, those of you who've been involved in any routine ministry inspection, they want to see those Joint Health and Safety Committee meeting minutes. That's a standard request in a normal times, normal thing. And certainly they will follow up on issues if employers refuse to implement a particular recommendation. So you should be prepared, if necessary, to explain why. So, I mean, be prepared. I would say it's my suggestion to you to be prepared for committee members with questionable positions based on internet research. Look, there is a lot of information out there that is being some of that information being trafficked by people in pretty high public office that is apparently of no merit whatsoever. We also know that that what is true today may not be true tomorrow when it comes to this. So you really, if someone brings forward a position that they've downloaded from the internet or heard on someone on TV or a radio talk show say, you want to verify that as best as you can with credible sources. And if some of these ideas are not included within the Ministry of Labor guidance, if they're not recognized, industry associations are a very good resource. Landon and I have been doing a fair bit of work assisting various industries and saying what we really should be doing or not doing in terms of what's credible. I mean, we're not safety professionals in the sense that we're developing it, but we certainly have a lot of experience dealing with what a decision maker finds credible and what is acceptable to courts and arbitrators. You probably want to get your Joint Health and Safety Committee going, and I'm thinking of those of you with offices, consider a virtual meeting. Like get all that stuff together before everybody comes back, because it's really, once if you have a protocol that the employees have had some input, you can avoid a lot of these issues, leading to some of the more, just making sure all the legitimate issues are dealt with, and you're just forced to deal with the ones that are legitimate. Hazard assessment. Employers should develop a formal hazard assessment process. I think if you don't have one, you should. There's a lot of resources available for that, and I recommend you do so. And I think one of the things that's most important, I think, is to remember that there are no certain answers to some of these questions, right? I mean, we know that a vaccine is being worked on. We don't know how long that's going to take. We don't know what future research may reveal about what measures are for COVID-19. Maybe some of the measures we're taking right now are not as helpful as we think they are, and maybe some of the measures that we should be taking we're not. But you just have to pay attention and remember that this is a moving target. And I guess that even things that, as I said, even credible research on important issues continues to evolve, as does the government guidance on these things. Controlling hazards have to be balanced against privacy and operational concerns. OHS legislation seeks to provide a reasonable level of protection. I mean, that's the standard, right? We sometimes forget, but that is the standard. The Court of Appeal has said so in Sheehan's Truck Center. You want to prioritize hazards and do so proactively. I mean, we know, I think, and address the highest risk items at the outset. Certainly, I'm just going to move to a hazard assessment scenario, and this is something I think could be contentious in litigation. Joint Health and Safety Committee of a 50-employee accounting firm recommends that anyone who accesses the facility be required to wear a non-medical mask at all times. That recommendation, I assume, sensitive to the fact that the shortage of the N95 masks, which continues to exist. The managing partner of the firm doesn't want people to wear masks. She feels that provides an uncomfortable aesthetic, and they're not required by law. She's worried about how clients will react to coming into employees with a bunch of masks. She calls her lawyer and asks what to do. Well, I'd say let's not use the word aesthetic when we're talking to the Joint Health and Safety Committee about a potentially deadly virus would be a good start. And I think that's the kind of recommendation that there is somewhere in the middle here. Certainly, where you can't social distance, requiring a mask is a perfectly fair precaution. And places that are customarily accessible to the public, many of them are requiring people to wear masks, requiring staff to wear masks. But every scenario is different. But providing a blanket policy like that and then basing the objection on we don't like the look of it has all kinds of very terrible implications. And even though, and I know, let's face it, that's what's on people's minds perhaps at time to times, but from a safety law perspective, that's not an appropriate issue. I've also been asked, and perhaps the last point, about what about our health and safety obligations to our employees that are actually working at home? The Occupational Health and Safety Act itself doesn't officially apply, at least on my view of its phrasing, to people working at home. It doesn't apply in a private residence, is what the Act says. There's been some dispute about whether that would apply in these circumstances to home offices and such. So, I mean, there's possibly technically not a strict obligation there. Well, certainly workers' compensation legislation has been held to apply to someone working at home. So certainly I think although it's a relatively low risk item, I think you should be communicating safety issues, remembering that, that particularly in some homes, you might be looking at a situation of, sort of strain type injuries and people being on their computers and not moving all day and the like. So those are my comments on occupational health and safety. There's an ability to ask questions through the software here. Those of you who have been with us know how to do that. You can just extend the questions on the sidebar here and type it in. Landon and I can answer those at the end of the program. In the meantime, I'm going to turn it over to Landon, who is going to address the various issues as they relate to returning to work in terms of employment law.
Thank you, Ryan. I'm going to be covering a fair bit of legal terrain today because the issues that employers are faced with do cover a lot of employment law terrain. They engage on human rights matters, privacy law, as well as under the Employment Standards Act. So I'll be talking about all of that, including a late addition to my agenda today is the new Employment Standards Act regulation you may be familiar with or have heard about. We issued an update yesterday about it. And I'm also going to be talking about constructive dismissal claims briefly at the end. So to start off, I'm going to be talking about returning employees to work. Surprise, not all employees right now are particularly keen to get back to work. For some, it's a matter of fear of the contracting the coronavirus, which is certainly understandable. And for others, maybe it's not minding being at home, watching some Netflix and collecting the CERB or EI, and maybe wanting to ride that out for the summer, who knows? Or perhaps all of the above. But in any event, we have heard from clients that have had issues with some employees not actually wanting to come back to work, where they are still able to operate under the law. So the first thing that every employer should understand here is that as an employer, you have the right to have your employees back to work if, of course, you're legally allowed to be operating and open, subject to human rights considerations, which I will be getting into in a moment. So to repeat, you can have your employees come back to work. You can require them to come back to work unless they have a valid human rights reason. Now, what happens if they refuse? What if you have people who just say, well, that's fine, I'm not going back to work? Well, the thing to know is that you're the employer. You have management rights. And first and foremost, you can discipline your employees who refuse to come back to work without a good reason. That may consist of perhaps initially a warning, verbal, written warning, perhaps escalating to an unpaid suspension if they still don't come back to work. And you can also terminate their employment. Now, before taking the step to terminate their employment, I would suggest that you give them a chance, a reasonable chance to come back. That, for example, the way I would not go about it is to send an email or make a phone call, Tuesday afternoon saying you've got to be back at work tomorrow at 9 a.m. And if I don't see you, you're fired. You could be exposing yourself to a wrongful dismissal claim or claim under the Employment Standards Act if you take that approach. So certainly I would give them a reasonable notice that they're expected back at work. And if somebody says, well, I don't want to come back to work or I can't, then you're entitled to the reason. So you can ask them what the reason is. And ultimately, if they don't have a good reason, which touches on one of the human rights matters we're going to talk about in a moment, then you can terminate their employment. And what I would suggest in those circumstances is if you do terminate, that you, in your termination letter, you refer to it as a job abandonment and note the fact that they were recalled to work when they were recalled and that they have refused to return without providing a good reason. So by calling it a job abandonment, it's essentially a resignation. And I think that's a more accurate reflection of what the situation really is, rather than, let's say, calling it a termination for just cause or something like that. And also then you would issue your record of employment and click off the box where it has quit as the code for the reason for issuing the ROE. And when the Service Canada people get the ROE showing a quit, if somebody is collecting employment insurance benefits because maybe they've been on a layoff or they are collecting the CERB benefit, then they may follow up with the employee and cut off those benefits. Okay, now we're going to move on to the human rights issues. So next slide, please. These are tricky issues. I think most of you on the on this webinar, this is probably not the first seminar or webinar you've ever attended that's talked about human rights accommodation issues. So you probably, just going back, previous slide, please. Looks like we flipped forward. So this isn't the first time you've probably heard about these issues or even dealt with them yourself. So I'm sure just about all of you on this webinar understand how tricky these issues can be. So really, again, this slide, you'll see I've got 3 bullet points, and these are really the 3 main ways I think employers are going to be faced with human rights issues. And now one thing I'll just say as a side comment on all of this, I'm sure that in a week or two there'll probably be more issues that we could talk about, because as I'm advising and helping clients with issues as they're working through this, new issues are arising all the time. So certainly possible we're going to see other kinds of human rights issues arise as well. But these, I think, are the main ones that most employers are going to be faced with. First and foremost, you're going to have perhaps some employees who have COVID-19. And of course, you don't want those people coming back to work when they have COVID-19. The Canadian Human Rights Commission, which issues policy statements and documents that are not binding law, has said in their view that having COVID-19 is a disability. And I think that is probably a fair reflection of what the Human Rights Tribunal or the courts would say on the topic. So you can treat anyone who has COVID-19 or even recently had it as well as being disabled. And of course, that means they're entitled to a leave of absence. You can't fire them, as many of you are probably aware. Back in March, the government brought in protections for people who have COVID-19 or couldn't work for COVID-19 related reasons. So those employees should be accommodated and given a leave of absence. Once they're recovered, though, and are tested negative, then of course at that point you can expect them to return to work, unless perhaps they are suffering from lingering physical disabilities as a result of COVID-19, which unfortunately as we learn more about this disease, we are seeing more and more cases where people suffer long-term complications that could last many months before they're actually capable of returning to regular life and work. The other area, the second area I'm going to talk about where we could get into human rights issues is with accommodating employees who have childcare responsibilities. And this engages the family status prohibited ground of discrimination under the Human Rights Code. And obviously this is going to come up so long as schools remain closed and daycares can only operate on a very restricted basis. Many employees quite simply aren't going to have care for their young children. And under the Human Rights Code, the term family status includes being in a parent and child relationship. Now, one thing employers should understand is that this duty to accommodate only applies insofar as employees have a real need to stay at home to provide childcare. It's not meant to accommodate a preference. So let's say, for example, someone's spouse is at home who is able to take care of the children, then you can expect your employee to come back. They might, even if they say, well, I prefer to stay home and help my spouse out with the kids, no, that's not good enough, right? But where you're probably going to run into the situation, of course, is where you have employees who are single parents or whose spouses are also working or as essential workers. So that's likely the scenario it's going to come up. And in terms of how the accommodation could be handled, well, there are several options. One, of course, is providing a leave of absence for so long as they're required to stay home to care for the children. But you might have other options. One might be flexible scheduling. So, for example, if their spouse is working as well, perhaps your employee can be scheduled on shifts that work and don't conflict with the spouse's work schedule. And as well, of course, there's good old remote working and working from home. And I think certainly, as all of you have experienced, and probably the vast majority of you are working at home, we've all learned to adapt to that and finding ways of helping people work from home that perhaps never occurred to us before. And then finally, we have employees with health conditions that you may have a duty to accommodate as well. You know, this could be a variety of health conditions. And again, as we're learning more about the virus, we are finding out that people with certain conditions could be at higher risk of serious complications from COVID-19. For example, people with diabetes apparently seem to be at higher risk. Other people might be those with immune disorders or lung conditions. So you're going to need to deal with each of those situations on a case-by-case basis. A lot's going to depend on how much risk they might be exposed to at the office or your workplace. For example, in what proximity they might be working with other individuals. And if you do have an employee who is seeking this kind of accommodation, you are entitled to information, right? You aren't forced to just take their word for it that they can't work as a result of their claim condition. And I would suggest that you ask for a doctor's note or letter or certificate advising that this individual is at risk of complications if they if they were to catch COVID-19 as a result of returning to work. Now, note as a general rule, you're not entitled to a diagnosis from the doctor. That would likely be overstepping your bounds as an employer, but you are entitled to the doctor's opinion that it's advisable for this individual not to be working. Okay, next slide. Screening. Now, employers have been taking a number of measures to try to protect employees who are returning to work, including temperature checks, questionnaires, self-reporting, and requiring doctor's notes and certificates clearing people to return to work. We're getting into tricky legal terrain. A lot of it is quite simply unprecedented legal terrain. And obviously we're getting into privacy issues here. And what we need to realize is that privacy law is still in its relative infancy in Canada. And Ontario is not a province that has privacy legislation that broadly applies generally to employers and employees. So we've got a bit of a vacuum there legally that's been filled in part by the courts, who have created a new tort, which many of you might be familiar with. It's been called the tort of intrusion on seclusion, which is basically a privacy tort that can give someone the right to sue for damages if another person invades their privacy without reasonable basis to do so. Now, in terms of the legal backdrop to all of this as well, we need to be mindful of the drug testing cases that are out there. And those cases have been decided for several decades now. And they address privacy concerns within the context of drug testing, as well as also consider human rights issues involving drug testing and the potential that it can be considered as indirect discrimination against those with disabilities, including drug addictions. So under that case law, there has developed a number of principles that govern when drug testing is appropriate, which I think has some application. It's not exactly the same kind of thing for some of the screening we're talking about, but I think some of these principles can and will eventually, when these issues start getting litigated, which they no doubt will, have some relevance, because the courts like to look to similar type of cases when deciding new ones. And some of those principles that have been decided under the drug testing cases include that, firstly, there must be a serious safety risk and interest on the part of the employer to be protected. Secondly, the testing needs to be accurate and deal with the actual risk involved, so that, for example, you're not just finding out that somebody took cannabis a month ago, but that there's an actual present impairment. The testing needs to be proportional and not unduly invasive. And as well, the employer can't have a policy where they simply say, if you test positive, well, then you're fired and you're gone. The duty to accommodate would also be engaged. So applying these principles to some of the kinds of screening that employers are starting to introduce, I'll first talk about temperature checks. I'll just say I've dealt with several clients that have implemented temperature checks in their facilities. These are manufacturing facilities. And I heard from one client that they actually caught a couple of cases of individuals with COVID-19 who were coming to work with a fever, incredibly, but it was happening. And so they prevented a further potential spread that way. Interestingly, in the clients I've talked to have unions in their workplaces. They haven't received grievances over these temperature checks. But just so we all know what we're talking about infrared temperature checks, where you can point the device at someone's forehead and it tells you very quickly whether or not they have a fever. So, so far the unions seem to be going along with it, at least the ones that my clients have dealt with. There might be others out there that are grieving it. And as well, the employees themselves seem to be supporting the temperature screen, because it seems to be helping them or helping to reassure them that they will be safe at work. My personal view on it is that temperature checks are proportional and reasonable and not so invasive that they run afoul of privacy issues in these circumstances. And when balanced against the employer's obligation to take reasonable steps to provide a safe workplace, I think there's a strong argument to be made that they are permitted. Now, just because they're permitted today doesn't mean you can have temperature checks, forever after the pandemic's over. Through history, every pandemic has eventually come to an end, and this one will too. And when that day comes, and we may not know exactly when that day comes, but when it does become clear that the pandemic is over and the immediate risks have subsided, then I would say it's time to put the thermometers away. And, because then I think when you look at tipping the scales between privacy and safety interests, that the scales will start tipping towards privacy again. A number of employers as well are using questionnaires and self-reporting as a way to screen out employees who might have COVID-19 or be at risk of having COVID-19. And some of these questionnaires can include checking off that you do not have some of the key symptoms of COVID-19. And of course, that's tricky because, again, the more we learn about this crazy virus, we're finding out that you can have a whole variety of symptoms or even no symptoms at all and still have the coronavirus. So again, it's not a magic solution, but it, I think there's a good argument that it's a reasonable proportional step to screen out people who are at risk of infecting others. So I would say that those questionnaires are okay, in my view. And then we have, I have heard of some questionnaires that go a bit further and also ask employees if they have family members working in frontline positions where they might be exposed to the coronavirus. I think there we're entering into some potentially dangerous legal territory. First and foremost, we've got the Human Rights Code that prohibits discrimination on the basis of family status. So if you were to say to an employee, look, I'm not going to allow you to come into work because your spouse works in a grocery store or is a nurse or a doctor or working in a long-term care home, then you'd be at high risk of a human rights complaint. Now, I don't know exactly what the Human Rights Tribunal will do with those complaints if and when they come. And maybe they will decide that, okay, that was fine for a period of time in the interest of protecting safety, but I think there's going to be at least some risk that the Human Rights Tribunal will find that amounted to a breach of the code. And then finally, when you have employees who have been sick, whether they've tested positive for COVID-19 or not, I think you are within your rights to require them to provide a doctor's note or certificate saying that they are no longer ill and can return to work without creating a risk. And if somebody has had COVID-19 or been tested for COVID-19, I think you're entitled to see the test result showing that they are negative. Again, with all this, there could be lawyers that will argue the other side of it, but I'm just giving you my take on it, and I think it's something employers can ask for and expect to receive as a condition of bringing someone back to work. Next slide, please. Okay, so I know I didn't do justice to a lot of very complicated human rights law there, but in the interest of time now, I'm going to move on to this brand spanking new regulation that the Ontario government brought down just a couple days ago, Ontario Regulation 228/20. And this regulation is very good news for employers because without it, they're facing a potential wave of determinations under the Employment Standards Act. And the reason for that is because, as many of you are probably aware, if an employee is laid off under the Employment Standards Act without benefits after 13 weeks, they are deemed to be terminated. And then an employee could put up their hand and say, okay, now I'm terminated, you have to pay me my entitlements to termination pay and if I qualify as severance pay under the Employment Standards Act. And so the clock's been ticking on that. And you know, the emergency order was issued March 17, 2020. And I know that's when many employers, most employers had to close and then lay off employees. So by my math, 13 weeks would have been hitting June 16 from that date. So this is welcome relief just a couple weeks before there could have been a wave of deemed terminations. And, you know, just for whatever it's worth, it seems to me that perhaps the government is signaling here that they don't think this is going to be over anytime soon. And it might be a while before we get into phase 2 or certainly phase 3 of their reopening plan. One other point, firstly, that this regulation only applies to non-union employees and not to unionized employees, because under their collective agreements, they typically have, the employer has the right to lay people off for much longer than 13 weeks typically. Okay, so employees who have been laid off or whose hours of work have been temporarily reduced are now deemed to be on infectious disease emergency leave. So what does that mean? Well, they're now on emergency leave under the Employment Standards Act, which is a protected leave, and means that they have a right to reinstatement at the end of the leave if their job exists, or to a comparable one if it does not, although the employee could still be terminated if their job has been eliminated for reasons completely unconnected to the leave. One other thing to know under this regulation, that ordinarily employers have a duty to continue benefits during a statutory leave under the Employment Standards Act. So this leave has exempted employers from that obligation. Next slide, please. Okay, so the upshot of being on the leave is that they're not on layoff, and the regulation also explicitly comes up and says that employees who have had their hours reduced and eliminated are not on layoff. So that the clock has stopped ticking on the 13 weeks for the deemed termination. And that will continue to be the case until the 6 weeks after the emergency order has been lifted. So once the emergency order is lifted, then employers will have some breathing room to decide what to do for reinstating employees. As well, the regulation states that employees with their hours reduced or eliminated and wages reduced or eliminated are not constructively dismissed under the Employment Standards Act, because otherwise employees could file claims saying that even if they haven't been deemed terminated, they have in fact been constructively dismissed, and then they would be entitled to termination severance pay. The exception is if the layoff or reduction happened before May 29 and the employee actually quit within a reasonable period of time. And as well, any complaints that have already been filed with the Ministry of Labor, Training and Skills Development are deemed to have vanished. So those, if you faced one of those claims, good news, it doesn't exist anymore. However, note that this only applies under claims within the purview of the Employment Standards Act. This does not cover constructive dismissal claims that employees might be bringing under the common law or even under contract. Next slide, please. So, if you have employees who don't have employment contracts with termination clauses that limit their entitlements to the ESA only, you could still be faced with lawsuits for constructive dismissal. And quite bluntly, the exposure is quite significant for those claims, especially if somebody is long service and they're found to be constructively dismissed. Well, I don't need to tell you that there can be a high price tag associated with their termination entitlements under the common law. And some of you may have already been receiving demand letters from plaintiff lawyers, as well as statements of claim initiating lawsuits, which people can still initiate statements of claim electronically with the courts, even though the courts right now are only hearing the most urgent and emergency type of matters. So yeah, if you're in that boat, or if you do get such a claim, don't panic. There are some options in terms of responding to them. The best approach would be to offer them their jobs back. Of course, that is not something that every employer will be able to do. But if you are able to offer their job back, even if it's may not be at exactly everything they were making before, then you'll at least have an argument that they failed to mitigate their damages, which can go a long way to reducing that high price tag I was talking about before in these kinds of cases. And you know, to have a good argument there, you need to show that the offer to come back to work was reasonable, that it's not embarrassing or humiliating for the person, and that if there isn't a particularly unpleasant or poison workplace that they'd be coming back to. So you want to be nice in how you say it and how you go about it, but it could go a long way to reducing your exposure and at least give you some leverage when negotiating with those nasty plaintiff side lawyers who like to you know, make all sorts of threats when they initiate these claims. However, if you're not able to offer the job back, even on a reduced basis, then, you know, there are still some arguments that can be made. First of all, I would emphasize the layoff being temporary. A lot of the cases where employees have been found to be constructively dismissed in the case of layoff involve situations where an employer just said, you're laid off, or don't come to work, we're not paying you anymore. And they didn't actually say you're on temporary layoff. So you never know, using the term temporary layoff may help. I think employers should also consider putting forward arguments that even though that regulation we're talking about does not technically apply to the common law, I think it certainly makes clear a certain legal policy that the government has recognized to help employers that are in an unprecedented and a precarious economic situation, and throwing employers a lifeline. So you know, I'm hopeful that the courts will also throw employers a lifeline in these cases, but we'll need to see. And finally, in certain situations, there might be a good argument on the employer side that the employment relationship or contract was frustrated. And what that means is due to no fault of either party, the whole basis for the employment contract has disappeared, and neither side can perform it through no fault of their own. I personally think employers in particular that have been ordered shut and who might have to remain shut for a long time, and one can think of theaters, you know, employers where businesses that involve gatherings of large groups of people, like caterers, for example. I think they're probably going to have a good frustration argument because the government just told them you can't operate. And if that goes on long enough, then I don't see what other option employers are going to have but to say that the employment relationship was frustrated. All right, so those are the slides I wanted to cover today. And now we're going to get to the most exciting part of the program today, which is the Q&A.
Okay, thank you for that, Landon. That was very interesting. You zoomed through a whole bunch of complicated material, and thank you for getting right on top of that regulation that was just dumped on us by the government very recently. First questions for you, Landon, is do employers need to provide formal notification of returning to the workplace? And if the worker refuses and not on one of the bases you mentioned, can it be considered a constructive dismissal if we have moved them home from a certain duration and then require them back in the office? Have we technically changed a significant part of their employment contract?
Well, first of all, the first part of it, which is the formal notification of return to work. By formal, I take it the questionnaire is really meaning in writing. And yes, I think anyone who's being called back to work, it would be best if it's done in writing so that it's documented. And now, of course, snail mail may not work for everybody, of course. So these days, a lot of employers have email for addresses for their employees. Some perhaps consider sending an email along with a phone call. Like there's no magic in terms of how you recall them back to work, but you want to be able to show that the employee knew that they were supposed to return to work, and that you gave them a reasonable amount of time, maybe a few days, to get back to work. So I would do so. Now, if you're in a situation where you can't reach them, and that's not unusual, where people move, they don't give you their new address, they don't answer their cell phone. I mean, nobody answers their phone anymore. So you might be leaving voicemails and not getting a response. In those cases, I would suggest you send a letter by courier to their last known address. You leave a couple voicemails asking them to call you back and saying that they're due back at work. Make notes of your efforts to contact them, dates and times of when you left the messages. And then ultimately, if you don't hear anything, then treat them as having abandoned their job and issue the record of employment. Now, the other part of it was, what if you have somebody who's now working at home, kind of likes working from home, and doesn't want to come back to work? Can that be considered a constructive dismissal? If they've only been working from home as a result of the pandemic, i.e. in March, they were starting to work from home, unless you told them that this was going to be a permanent arrangement, I don't think they can say that now having to come into the office is a constructive dismissal. And remember, you're the employer, right? You have management rights, and that includes having people report to work at your workplace. Now, you might have people who complain and say, well, I can work just as effectively or better from home, and there's now research where some people are suggesting people are more efficient from home. Well, you as the employer have the right to be wrong, okay? Even if people are more productive and happier at home, you have the right to drag them into work. Again, subject to the human rights issues, subject to whatever orders are in place from the provincial government, and of course, subject to the health and safety factors and any work refusals you might get. But as a general rule, you can ask them to come back to work at your workplace.
Thanks, Lennon. Next question's for me. How about if an employee gives multiple reasons? This person is given the gamut of the kind of reasons that people that might be particularly sensitive to COVID-19 for whatever personal or human rights-based reasons. I'm diabetic, I live with my elderly parents, I don't like the commute because the commute's too dangerous for not returning to work. Is that close enough to workplace refusal based on safety? That type of, go back to the slide, I'm not going to, but if you look back at the slide when we send them out to where the Occupational Health and Safety Act work refusal provisions, that doesn't, in my view, isn't covered by the Ontario Act. It's just in terms of having a specific statutory right to refuse to work. It's not about the physical condition or workplace hazards. The legislation was written from a very 20th century industrial workplace perspective, and it wasn't contemplating pandemics and external factors. And unless it's amended, it's not a work refusal. But that's not the end of the story, of course. I mean, you still you still have to take certain obligations, but to some extent, you can't control the commute. I mean, if the person, you can't control where they live and can't control how they get there, save and except for perhaps providing a parking spot if it's not available or whatever. But ultimately, you want to be alive to certain human rights realities. But I mean, at the end of the day, it would have to be a specific case that someone is medically specifically not able to return to work, and it becomes an accommodation issue more than an occupational health and safety determination of that kind of issue. And I guess that leads into another question that for Landon. It's somewhat similar. I have an employee who has a spouse who works in a long-term care facility, and she is worried about coming into the office with the possibility of infecting him, which may infect patients. How do I advise her?
Well, I don't know what kind of a workplace the questioner has. It sounds like they referred to patients. So that would obviously be a serious concern. Yeah, it's so without knowing more about the situation, it's difficult for me to say what the right approach would be, except I would just say it sounds like you've got to take this one really seriously.
Yeah, I agree. I think when someone actually is in a situation where they're actually routinely accessing a facility which is known to be a hotbed for COVID-19, and there's more fatalities in long-term care facilities than almost anything else, and there's certain other sensitive areas. I agree with Landon. That has to be very carefully assessed. Next question for Landon: does the new regulation?
Just getting back to that question. From what I heard from the question, it sounded like the employee themselves was raising the concern.
It was, yes. That's it.
Yeah, so that's really helpful for the employer, because then it's easy for the employer to say, okay, in that case, you know what, take a leave, stay home, don't come in, right? Collect the CERB. That makes things easier. Where it would get trickier is if you have somebody insisting to come into work, despite the fact their spouse works in a long-term care home. So so this is a situation I think probably the employer can work with the employee on, right? And it can be a win-win.
Yeah, I think you're right, Landon. It's, you're right. It's certainly easier than the other way around. Next question for me is, Ryan, would it be prudent for the employer to provide a list of what has been implemented as far as health and safety protocols to reassure staff it's safe to return to work? Yeah, I would agree that it absolutely is. Very good idea. I think it's a very prudent practice. And I think, again, as I mentioned earlier, you want to share any documents you've received from the landlord or people who have control of the facility with employees, so it's clear. A question's been raised. I think the commute is a valid concern for some employees. Yeah, I think it is. I mean, I don't think there's any doubt about that. And even, and I want to be clear, just because the work refusal provisions perhaps don't contemplate dealing with that issue, it doesn't mean that someone doesn't have a legitimate common law or other basis for not being able to go. So you want to work with, you want to, where you can, be reasonable with people in terms of maybe providing them parking if it wasn't happened, or structuring their hours in such a way so that the commute is better. Or I mean, because the alternative really is, if you can't accommodate it, either the person no longer works for you, or they work from home, or they are going to have to work somewhere else, because at some point, at some point it may be, if it goes on long enough, it goes back to Landon's comments about frustration of contract. Next question is for you, Landon. We have a staff person who has been accommodated to work from home due to health risks. That employee is not fulfilling their obligation from home and is incurring many complaints from other program and staff of the organization. I'm not going to name the type of organization it is, but it's a government facility. Is it reasonable to tell that employee he must return to work on site or take a leave of absence?
Well, I heard in the question that they're working from home due to health risks. So I don't know what those health risks are, but I think that's the first issue I think the employer needs to look into, is to consider whether or not the health risks are reasonable, and whether the person has a good, basis to stay at home. So as I talked about in the slides, I think the first thing to do is to nail that point down and ask for medical documentation to support that. And if the person does provide medical, an opinion from particularly a doctor or other reliable medical professional that they can't work due to health risks, or shouldn't because they're at elevated risk of complications due to COVID-19, then I would say, okay, keep them out of the workplace. But it doesn't mean you as the employer then have to settle for substandard performance, right? So then, just like you would with somebody who's working in your workplace, I would suggest that you follow progressive discipline and, you know, try to manage their performance and deal with it that way. Because, you know, just because they're working from home, you know, maybe or maybe not, it makes it more difficult to manage them, but you can still manage your employees even though they're working from home, right? And you still have that right. Now, if it turns out that there isn't a solid medical reason for them to be working from home and you think the only way it's going to work is to have them into the office, then you can do that, right? You can bring them in. Again, subject to the medical issue and if you can be satisfied that there is no solid, good medical reason for them to be avoiding your workplace.
All right. Next question is, I also feel, and it's a human rights question. How much accommodation do I need to give to a married parent? She claims her husband can't take time off or is not permitted to work from home. Why do we have to give all the accommodation when the other parent can continue working?
Well, that's a good question. The first thing that I would suggest you do is ask for more information, and that would include what the other parent does, their occupation, and what their hours of work and working schedule is, and see if you can work around that, as well as ask them to confirm that they've asked for some accommodation on their end, and then see where that takes you. But that's one thing in the case law that's dealt with family status accommodation that's been made clear is that the employer is entitled to some information. And if the employee just refuses to provide the information, then the employer is within their rights to deny the request for accommodation. So that's what I would do, and then see where that takes you.
All right. Moving back to the safety world, what is the standard protocol if an employee that is working has tested positive for COVID-19? Do we need to get others that have worked with them tested? This engages a couple of things. I mean, certainly up until recently, access to COVID-19 testing was complicated. But certainly here, yeah, you certainly are going to want to have employees that have been in contact be tested. You probably, an issue that wasn't asked, but as a corollary of this is, do you identify that employee? And I'm going to suggest you don't. Reality is that employee may very well be identified anyway. Reality is that these individuals will probably be contacted by the local public health agency as part of the contact tracing effort, contact tracing being the process by which people who have come into contact with a person who's been infected with COVID-19 are notified so that they can self-isolate to avoid further community spread of the disease. Next question, and it's a good one. Would the definition of workplace apply to home office for those who have to continue to work? If so, would reasonable precautions be to review the internal responsibility system, the ergonomic workstation, setting up, taking breaks, some standing desks, etc.? The question here is, this is an interpretation of a very narrow section of the Occupational Health and Safety Act, which specifies Section 3 sub 4, which deals with this issue, and it basically says, it gives an exemption and says that the act does not apply to the home workplace. That, not to avoid getting overly legalistic, there's not been a whole lot of court comment on this. There was an occupational health and safety reprisal case brought by a telecommuter, a harassment case dealing with someone who worked exclusively from home. And that case continued to go forward without any jurisdictional issues. The issue just wasn't addressed. But arguably, if the act didn't apply, potentially could not have applied to that employee. However, WSIAT, the Workplace Safety and Insurance Appeals Tribunal, in a specific case dealing with dealt with a case where an employee argued that they shouldn't be required to work from home because they're not protected by the Occupational Health and Safety Act. And the WSIAT did agree with the employer they weren't protected by the OHSA because it doesn't apply, but still ultimately made them proceed. So that's the legalistic answer. I think the practical answer is to do all the things that the questioner suggested, that because workers' compensation claims still apply to a home working situation, you would want to do all those things. And plus, it's just a good practice. I mean, and especially because, quite frankly, I can't tell you conclusively that the act doesn't apply. The way that exception is written in a very nebulous written 30 years ago kind of section. And we've learned many times going to court that they sometimes give interpretations to things that are sometimes somewhat beyond the language of what's actually in the document. Question going back to Landon. Can we suggest an unpaid leave of absence if the staff cannot fulfill their duties because they can't come into work due to childcare issues?
Absolutely. And that's a good point. I probably should have mentioned before that when we talk about the duty to accommodate under the Human Rights Code, it does not mandate or require that the employer pay people who can't work due to a prohibited ground or a ground of accommodation under the code. So you're certainly within your rights to make the leave unpaid, and that's fine. Now, of course, if you have policies that provide for various forms of paid leave, well, those might be engaged, especially if you're unionized and have a collective agreement with some of those provisions. But otherwise, that's a simple answer, and yes, it can be unpaid.
All right. Next question, I'll take it, is, are thermal body scanners considered to be a breach of privacy? So that would be like a mix between a thermal and an X-ray. The issue is, like, one of the things that you have to understand about privacy law, at least as it is in Ontario, is it's an emerging issue, right? Like, there's a tort recently developed about sort of the intrusion on seclusion, meaning sort of judge-made law is starting to recognize it. But unlike some provinces and in the federally regulated sector, there's no real law statute. There's an Occupational Health and Safety Act. There's not a Privacy Act that applies to the private sector employers provincially regulated in Ontario. So it just becomes a question is how one deals with that. And I think that even the unions, as Landon had mentioned, have not been overly militant about this. As long as the as long as the body scanner isn't violating, is not at risking putting someone their health at risk otherwise, and it's just simply checking their temperature strictly for the purpose during this pandemic of looking at COVID-19, I think it's perfectly appropriate to take that step. But I mean, but ultimately we just don't know. That's just how that's going to go. Ultimately, some arbitrator in particular, that's how these things often do get litigated, a la drug testing and other these kind of tricky issues. We'll see. But I'm not sure that that's going to be that many people are really going to seriously suggest that making sure they don't have a fever is a breach of their privacy. Landon, what happens if we don't recall an employee after 6 weeks? Is it a deemed termination? What is the termination effective date? Date of layoff or date the decision is made?
Sorry, after 6 weeks on layoff? Well, I don't know if they're referring to that regulation that says that it applies for 6 weeks after the end of the emergency leave. And, in that case, once that regulation gets lifted, then, we'll have to see exactly what the government says. But I think then there's a good chance if it's just simply expired, then we're going to, see the terminations happen, and it's going to be from the date of the initial layoff.
The next question is for me, is a reprisal question. What if someone refuses to work on their first day of work? What if it's been less than 3 months? Is firing them still a reprisal? Well, here's the thing. It doesn't matter how long they've been there from the perspective of a reprisal. I mean, I know obviously like 3 months is usually sort of the threshold for a probation employee who can be then terminated under the SA and usually common law as well without notice. But in these circumstances, if someone's worked for you for 1 minute, they're protected by the Health and Safety Act. And if they refuse to work on the first day of work, you have to engage the process. And let's just sort of, first of all, are they exempt? Is it a work refusal within the meaning of the Act? Remembering that I've talked about what is and what isn't. And some of these things are not. Remembering it's a very 20th century industrial model about the condition of the workplace, not, it's other liabilities. But assuming it's about the condition of the workplace, you then have to evaluate, is that person is that person exercising their rights under health and safety law? Do we feel that we've are in a position to say that, look, these are the precautions that we've taken and the job is here, do you want it or not? I mean, if it's a short service employee and you can really genuinely say, look, it's not a reprisal, the person simply is, we have a job and they're not doing it. So they're terminated. But I mean, you have to be very careful in those in those circumstances to make it clear that the termination is basically focused on the person not being interested in working, and that the safety issues aren't a concern. It's those kind of situations. It's very self-serving of me to say so, perhaps, but those are the kind of situations where you do really want to get your lawyers involved, because there's so many different things that could come into play there, not just occupational health and safety, but also human rights, also employment law, and those sort of things. And I mean, this is a question and we're starting to get short on time here, but we'll see what we can do here. This one is for Landon. What if initially during the pandemic we accommodated workers to be working solely from home, but now as we are slowly expanding our services, we need them back at the office? We have a doctor's note stating that they need to stay out of the office now due to stress. But if we initially accommodate them, do we need to continue to accommodate? I mean, and then the person goes on to talk about some more of the specifics, but Landon, in general, because we've let someone work from home at the start of the pandemic, does that mean we have to do that forever?
No. So the employers are within their rights to require people to come back to the office, again, subject to whatever requirements that the government's been imposing, or restrictions in terms of reopening your workplace. But you can require people to come back to work. And again, subject to the human rights issues. And the good old doctor's note that says the person's too stressed to work. Well, first and foremost, stress is not a disease. It's not a medical condition. Stress is something all of us experience on a fairly regular basis. So, but the question is, does that mean the person does actually suffer from a disability, such as perhaps chronic depression or something like that? And so I think rather than just taking the doctor's note at face value, then you as the employer have the right to further information to see if in fact you're dealing with something that does require accommodation. And you get into tricky issues there, and I would suggest you speak to your lawyer to get some advice on that. And what I would generally advise a client is to send an appropriate questionnaire to the doctor, seeking some more information in terms of whether or not the individual could be accommodated, and what the expected duration would be, as well as generally the nature of the condition. And ultimately, if things get, you think someone's really like just in bad faith, trying to avoid coming back to work without good reason, sometimes you can require them to attend an independent medical examination where they might be examined by a professional that has, more training than a GP in terms of dealing with mental health conditions, such as a psychiatrist or psychologist.
All right. Thank you, Len. That's helpful. I mean, and Len is quite right. Stress is not it's not a disability that's been litigated before. There are certainly DSM-4 recognized stress conditions, like chronic stress, for example, but those are two different things, right? I mean, it's certainly kind of, if I can make the difference between someone, for example, who may miss work because they're hungover, is not necessarily someone who is an alcoholic in the clinical sense, right? I mean, it's maybe someone with bad judgment. Next question is for me, is what about the refusal to wear a mask? We have an employee who is refusing to wear a mask, and I won't say what it is, but their workplace environment involves interacting with the public, and the staff member is simply refusing to do so. Well, that, to my perspective, I don't think there's much doubt, based upon the currently available guidelines for health and safety, that masks are considered to be a necessary precaution when social distancing isn't practical, and even otherwise. On these facts, this is, to me, is similar to a construction worker saying, well, I don't want to wear my hard hat. Well, you kind of have to, whether you want to or not, because that's what's necessary for safety. So this is a disciplinable issue. I mean, certainly, unless the person is trying to raise some type of accommodation issue, like you've seen with hard hats, there's been the odd cases where someone's religious garment makes wearing a hard hat impossible or difficult. So if there's something, unless it's something along those lines, wearing a safety mask, that's a safety rule. The Occupational Health and Safety Act imposes an explicit obligation on employees to follow the employer safety rules, and this is no exception. It's disciplinable, and it is a safety issue. I think we have time for one more question, which I'll just ask for Landon. Is we at the start of the pandemic had historically started paying for employees who were taking public transit to work and gave them chits for taxis or Ubers or ride shares, things like that. Now we have more people coming back, and that's getting to be very, very expensive, and it's not something we think we can afford. Are there any repercussions to us for stopping this temporary measure that we had started for people coming in by funding their ride shares or taxis?
Well, you're within your right to stop doing it. Obviously, that was a very generous and I would hope appreciated gesture by your employees. But just because you've been doing it doesn't mean you have to keep doing it. And there's no legal obligation to continue to pay for people's commute into work. And I'll just say, like, as much as probably none of us would be too thrilled about being on transit. I was actually on a TTC streetcar yesterday. Not for a long time, but I was on there, and I seem to be okay today. And these services are still running. And as far as I know, Ryan, correct me if I'm wrong, but I don't think the ministry has said that employees can refuse to come into work because they're afraid of catching COVID-19 on the TTC or GO train.
There's no such there is no guidance on that issue. So you're quite right. I agree completely with that. It was a generous gesture by the employer, but it does not convince you to commit you to time immemorial to paying for an employee to get a private ride to work. It was a generous gesture. So I see there are more questions, but unfortunately we have reached our time. I'd like to thank all of you for turning out. Landon and I and the firm greatly appreciates you coming to our webinar and listening to the Landon and I's thoughts on these matters. I'd encourage you to pay attention to our website. We routinely write about issues related to COVID-19. We try to make our writing as helpful and practical as we can. So we encourage you to do that. The slides will be made available in the usual process by way of an email and a survey that we will be sending out shortly. Again, if any of you want to reach out to ask us any of the more complicated questions, please reach out. That's what we're here for. Otherwise, I thank all of you for participating and hope to talk to some of you soon. Thanks.